I want to welcome everyone to Judiciary Full Committee for this week. Mr. Clerk, if you'd take the roll. Has everyone had an opportunity to participate in the roll call process today? And as I'm looking around, I see Representative Salinas, would you? Thank you. Okay. Ms. Clerk, we take the roll.
Mr. Chair, you have 16 members present. You have a quorum.
Okay, thank you. Excuse me, Madam Clerk. Appreciate that. Once again, I want to welcome everybody to committee today. Members, have any personal orders or announcements before we get started? Representative Alexander, did you have something? No, I'm sorry. Okay. I didn't know exactly. I thought, well, all right, good deal. Well, that brings us to our calendar today. We have item 1. We have House Joint Resolution 49. Excuse me. Oh, I'm sorry. If we could hold on that, members. Representative Salinas.
Hi, thank you. I just wanted to welcome Conexión America, who's here with us today. I wanted to welcome the students, the staff, the board members of that organization that provides family in our community, in the Latino community, ways to integrate into our community at large. And they offer services like college success programs, English classes, financial information, community outreach, and legal information. So if y'all could please help me welcome them to our building as they become rising new Americans.
And then thank you for that. Members, anyone else? Chairman Doggett, you're recognized.
Thank you, Mr. Chairman. I'd just like to wish my father, Big Al Doggett, a happy 70th birthday. He is not watching this, so he may not ever see it. But in the event he does figure out how to use his smart device, he may go back and see it in the future. But happy birthday, Dad.
Very good. Members, anyone else before we get started? Also, Madam Clerk, if you'd let the record reflect, Speaker Sexton is present in today's meeting as well. Chairman Howell, you're recognized. You've got a motion in a second.
Thank you, Mr. Chairman. Committee, it's good to be with you. HJR 49, which is a proposed constitutional amendment for bail bonding, was passed by this General Assembly in the last session. Of course, it must be passed again this session if we are to allow the voters of Tennessee to decide if our judges should have the discretion to keep violent criminals in jail or set them free, as they are required to do now with bail, while awaiting trial, and that's what the Constitution requires. Let me give you a hypothetical situation, I think, to put a face on the situation that we have. If my beautiful 5-year-old granddaughter is raped, or God forbid, but if she's kidnapped and taken for child sex trafficking, under the current Constitution, the judge would have to let the alleged rapist go, at least set bail. If he can make bail, he would go free under that situation. This makes absolutely no sense to me, and I would have to say I believe a majority of Tennesseans. Let me read you what the Constitution says. all prisoners, all of them, all prisoners shall, you know what shall means in the law, be bailable by sufficient sureties unless for capital offenses, which is murder. And this must happen even, and quote, when proof of evidence or the presumption is great. I believe the voters of Tennessee want to change that, and this proposed amendment, constitutional amendment, if approved, would give the judges the ability to deny bail if there is a preponderance of evidence that they are a flight risk, or if there are other indicators that the subject would be a continuing threat to public safety and is set free on bail. Under this proposal, the judge can still set bail. They have that discretion, but they will have the discretion also to deny bail if that situation warrants. I believe the people of Tennessee are tired of the revolving door in our justice system, and I believe they want us to address this, and that's what this HJR 49 attempts to do, and I urge you to listen to our constituents and pass this HJR. Thank you, Mr. Chairman.
And thank you for the explanation, Chairman Howe. Members, we do have testimony on this bill. Committee members, would you all like to go out of session now, hear testimony, or would we want to take questions from the sponsor of the bill? Been in the motion to go out of session. Any objection? I'm seeing no objection. We'll go out of session and hear from, I have on the list, I have Steve Crump with the Attorney General's Conference. I have also Mike Dunn as well. And then I have Rafael Manguel. Guys, if y'all just step on up here, somebody's leaned against the lights, turn those back on. Close. There you go. Thank you. All right. All right. Thank you, gentlemen. Gentlemen, you all each will have 3 minutes apiece, and I'll let you all decide who wants to go first, and we can have unlimited time for questions. Looks like Mr. Manguel, you've been chosen. Your light came on first. Sir, if you would go ahead, just introduce yourself. Appreciate you being here today.
Thank you very much, Mr. Chairman, members of the committee. My name is Rafael Manguel. I'm a senior fellow with the Manhattan Institute for Policy Research. I'm going to go right into my testimony today. So the first duty of the government is to provide for the safety and security of its citizenry. And that's something that's done primarily through criminal justice systems. Public safety should be the most important consideration of the justice system at every single step of a criminal case's progression, including the pretrial release inquiry. In the ideal system, that inquiry provides an opportunity for incapacitation through the detention of defendants that are judged to pose a significant risk of reoffending during the pretrial period. A system that categorically prohibits criminal court judges from taking such a step for the benefit of the public safety is, by definition, falling short of its primary duty to its people. To illustrate that point, I'd like to tell you all a story from my hometown, home state, I should say, of New York. In the fall of 2022, a 40-year-old mother of two named Kiara Benefield was savagely beaten by her husband in their home. There was no doubt as to her husband's guilt because the beating was captured by their home security camera. The police did their job in arresting Kiara's husband. Prosecutors did their job in charging him. But because New York state law prohibits judges from remanding defendants like Adam Benefield based on public safety risk, even in cases involving brutal domestic violence, this ruthless defendant, who had previously been convicted of kidnapping an old girlfriend at gunpoint, was released. The next morning, he found Kiara Benefield and shot her in the head in front of their children. So certain was Kiara Benefield of the threat to her life, a threat that the government should have protected her against. She was actually wearing a bulletproof vest when she was shot on her way to take her children to school. Now, what happened to Kiara Benefield is not anomalous, sadly. A study done by the Bureau of Justice Statistics looked at those convicted of violent felonies in 75 large urban counties between 1990 and 2002. That study found that 12% of those offenders were on release pending disposition of a prior case. In my home city of New York, we see similar numbers as indicated in an analysis by the Mayor's Office of Criminal Justice, which reported that the share of violent felony arrests constituted by those with open cases hovers at around 25%. Many of these serious crimes could have been avoided if judges had been given the discretion to exercise their judgment and make a determination as to whether it would be appropriate to release particularly risky defendants prior to the dispositions of their cases. Now, one argument that has been made in opposition to this amendment proposal is that it will be costly, but I urge you to consider that crime too is costly. A 2010 study of crime-specific cost to society noted that more than 23 million criminal offenses were committed in 2007, resulting in approximately $15 billion in economic losses to the victims and $179 billion in government expenditures. And there's also a point to make here about fundamental fairness. Giving judges the discretion to jail defendants.
Oh, Mr. Mangwell, I'm sorry that your time had ran out there, so well, I'm sure we'll have plenty of time for questions, and that question may pop up there. Mr. Crump or Mr. Donovan?
Thank you very much, Mr. Chairman and committee. My name is Stephen Crump. I'm the Executive Director of the Tennessee District Attorneys General Conference, and I am here today in a very unusual circumstance. For the first time since I've been associated with the conference, we have taken the position of issuing not just a resolution in support of this bill, but also to be committed to going around the state in our various districts and working to see that this bill is passed and voted favorably for if it becomes a ballot initiative in the next governor's election. I do not recall a time when we have found a bill that is more significant or more important to the concept of public safety than this bill. We have helped both Speaker Sexton and many people sitting in this committee with a number of very important bills, but none on a day-to-day basis affects the safety and, frankly, security and well-being mentally of victims of crime than this. I'll finish with just this comment. We have heard we are in a state that is traditionally either the first, second, or third most violent state in this union. We constantly are dealing with the issue of violent crime. For years, those who have recommended and advocated for criminal justice reform have told us that jails are supposed to be for those that we are afraid of and not those that we are angry at. These are the people that we are afraid of. The people that this bill touches are the people that we fear. They're the ones that when we close our eyes at night and there's a noise in the house, it's who we imagine there. So I would encourage you, I would ask you, I would implore you to vote for this measure. It is essential for Tennessee's victims. Thank you.
And thank you for that, sir. Mr. Donovan?
Mike Donovan, Deputy Executive Director, Tennessee District Attorneys General Conference. I'm a career prosecutor. I served as an elected district attorney for 11 years, from 06 to 17. I come to you to speak in support of this bill as well on behalf of the district attorneys, but also with a little different perspective. For 4 years after my service as district attorney, I served in the Department of Justice as a federal prosecutor, and I will let you know that the resolution that you're being called upon to examine and vote on today is very much similar to the current federal law under the Bail Reform Act of 1984. That is, typically monetary or surety bail in the federal system is somewhat rare. That is, under the Bail Reform Act, the federal law, you are either detained or you're released pretrial. But on the issue of detainer, there is a statutory framework that Congress has established that indicates that for certain offenses, there is a rebuttable presumption that you shall be detained because you are either dangerous or you're a flight risk. And so this actually would be consistent with what's already going on in federal law that Congress has passed 30 years ago. The last thing I would say is that this is not the only constitutional amendment that you'll be voting on this session. The other one involves strengthening the rights of crime victims. And I would say to you that this bill, as well as that one, will strengthen rights and protections for victims. Thank you.
Thank you, sir. Members, our guests are available for questions. Representative Hardaway, you're first on the list. You're recognized.
Thank you, Mr. Chairman, and I wasn't ready. I thought I was down the way. Good afternoon, gentlemen. Thank you for being here. On the level of proof that's available to the prosecutor and judge at the time, what level of proof is necessary right now for these crimes?
Mr. Crump?
in setting bail?
Currently at this time, it is a presumption on the issues of that are in front of the court. The current language in the Constitution says that bail is always going to be viewed in terms of where the evidence is strong, or evident, where it's evidence, where the proof is evident, or the presumption is great. And so that would not change by the passage of this. The presumption, the proof level would remain the same.
Mr. Hardaway, any follow-up?
Yes, sir. And this is something that I support. I think we have situations now, you can correct me if I'm wrong, whereas with a wink and a nod, that some judges, though they're looking after the public's interests in denying bail, it's kind of sketchy as to whether it's a constitutional violation.
Mr. Crump?
I think part of the issue is this, and I've heard this argument in the past about this, that well, right now you can really deny bail. You can just set it so high that the person can't make it. That's patently unconstitutional. That is not a constitutional way to conduct business. Even though that may be the case, if that is the way you're approaching it from the outset, that's wrong. This would frankly free judges and give them the discretion in an appropriate case to deny bail. We trust our judges to do this now in terms of setting the amount of bail. It will only change the nature of their inquiry and not either the evidence framework that they look at. And it certainly, I think, will frankly make us a more constitutionally compliant state.
President Hardaway?
Thank you, Chairman, and thank you for that complete, cogent response. I'm sometimes having trouble when I'm talking to some of my constituents on why I do support this bill and helping them to understand. So thank you for that. Thank you, Chairman.
Thank you. Representative Balso, you're recognized.
Thank you, Mr. Chairman. My question is for General Donovan. Thank you for being here. And I want to follow up on your experience comparing both the federal system and the state system, because obviously we've got Article 1, Section 15 of the state constitution dealing with bail, and we've got the excessive bail clause of the 8th Amendment of the U.S. Constitution. And is it accurate that the U.S. Supreme Court has ruled that there is no absolute right to bail under the federal Constitution?
Mr. Dummett, you're recognized, sir.
Yes, that's correct. In a case in 1986 called Salerno, the Supreme Court ruled that was the case, in fact. And again, the Bail Reform Act that Congress passed in 1984 establishes a series of procedural steps that must be taken by the government, but those are based upon presumptions in certain categories of crimes that are alleged. Typically the ones that are in the list that you'll see that are attached to this resolution, the most violent, the ones that involve firearms, the ones that involve victims, particularly child victims, those types of offenses, there's a presumption. And then, of course, there is a right to a detention hearing where the government has to put on proof. There's due process. And the magistrate judge has to reduce those findings to writing, and those are subject to appellate review. So absolutely.
Representative Balso, any follow-up, sir?
Just one, Mr. Chairman. And would it be accurate to say, General Donovan, that if the people of Tennessee adopt this constitutional amendment, that it actually aligns the Tennessee Constitution more closely to the U.S. Constitution, and in particular the Supreme Court's interpretation of the 8th Amendment's excessive bail clause than is the case right now?
Mr. Dummett?
That would be my opinion, yes.
Very good. Thank you. Are you finished up? Thanks. Representative Harris, I have you on the list. Representative Harris, you're recognized.
Thank you, Chair. And I also wanted to say thank you for being here. But two questions. What data shows or what have you seen and experienced to this within other states that says that this will reduce significantly crime within our state?
Mr. Manuel, was that a question that would be appropriate for you?
Yes. So just to reiterate, I mean, I would point you to the study done by the Bureau of Justice Statistics of all convicted violent felons throughout the 75 largest urban counties over a 12-year period. That study again found that 12% of those individuals committed their crimes, excuse me, while they were out on pretrial release. In my home city of New York, the number hovers at around 25% of violent felony arrests constituted by people who have current open cases. So, really the key point to understand here is that a not insignificant portion of the most serious crimes committed throughout the country are committed by people who are out on pretrial release.
Representative Harris, any follow-up?
Thank you, Chair. And with all of that, if the amendment passes, how would if a judge still made the decision even afterwards to still release somebody out, is there any repercussions on our end that we have to deal with? What happens after that?
Gentlemen, Mr. Crump?
I don't believe that there would be any repercussions internally from not following this necessarily. However, should that conduct rise to the level where the Board of Judicial Conduct felt like that a judge was not upholding his or her oath, then they could certainly have that finding. Upon their second finding, that gets referred to this body for removal, or at least for the review of what could happen.
To answer your question, Representative Harris? Are you finished up? Okay, very good. I have Representative Johnson. You're recognized, ma'am.
Thank you. Curious about a statement that you said that excessive bail was a concern constitutionally. However, this was was not a constitutional issue. We're literally changing the Constitution to allow this. So, I mean, that's what we're doing here. I guess, what is your argument that this is more constitutionally sound?
Mr. Crump, you're recognized.
As has been stated, there is no federal constitutional right to bail. The right to bail in Tennessee is controlled by the language of the Tennessee Constitution. The Tennessee Constitution says that everyone is entitled to bail at this point, unless you are a capital offender. If a judge were to say, you know what, the Constitution doesn't allow me to set this bail, but I know this defendant can't make a $5 million bail, that is going to violate the Constitution, both of Tennessee and the United States, because it is an excessive bail, potentially. I mean, it would depend on a lot of factors, but if the idea is, I know this person can't make this, by changing the Constitution, what you're allowing a judge to do is look at it and say, this particular defendant with this particular circumstances and this particular circumstance in a community does not lead me to believe that this person is safe to be among us. Not everybody, but just this person. And so as a result, there is no violation of the United States Constitution. There would be no violation of the Tennessee Constitution. A judge could do what they fully and truly believed was necessary to secure the citizens wherever they represented.
Representative Johnson, any follow-up? You're recognized.
Yeah, but currently this would be unconstitutional. That's why we have to make a change to our current Constitution, because the people who wrote this Constitution believed that that bail should be available. So I think we have to be honest about the fact that we are changing this, because it would be unconstitutional if we were to do this currently. I guess my question, and I don't know if this is a question for you guys or for the sponsor, but my concern about this bill is that it's not final. If things are added in the next year or the next session, there are things that could be added. I have a problem voting for something that I don't know the full realm of what is potential to be the offenses that are included. You're asking us to vote today on the offenses that are there currently, but over the next year, 2 years before this fully gets to a ballot, there is the opportunity to change this. Do you know of any changes or additions that are in the works before this takes effect if we were to vote on this today?
Mr. Crump, you're recognized.
I'm unaware of any changes that are proposed, but obviously I don't know the mindset of all of you in the General Assembly or in Governor Lee's office. But currently the Tennessee Constitution says that bail can be denied for capital offenses. And over the history of the United States and Tennessee, the definition of capital offense has changed remarkably. If you go back to the original Constitution, it included stealing a horse, which obviously is no longer there. If you look at the federal Constitution, the death penalty is a capital case is treason. It can also be being a drug kingpin. And so the definition of what is covered currently is subject to change constantly. And so it does not create pause for us as people who would be arguing and dealing with this every day that there's some constitutional infirmity because of that language.
Representative Johnson, to answer your question.
Well, someone else wanted to say something as well, I think. So.
Excuse me, Mr. Donovan, you're recognized.
I was just going to add to answer your original question that our understanding of the reading of the resolution is that once it's passed, if it were to be passed, it'd be placed on a public referendum. And by the time that there's a gubernatorial race, whatever laws are in effect that would be within that list of offenses would be public chapters. And I emphasize the word public. They would all be public. We'd all know what they are. Voters would know what they are. They're public.
Representative Johnson.
Yes, but today for this vote, it's not final. There could be things added. So we are being asked to vote at a time when more offenses could be added. And I find that concerning that that's open-ended at this point. But thank you.
Next on the list, I have Representative Towns.
Chairman Farmer, thank you. And thank you, members, for obviously standing there working together, trying to figure some resolve to a very difficult, complex question. Unfortunately, in this world, people are crazy, they're vindicious, and they're not wired right. And some people are vindictive, and they want to take things out on other people. We had an employee here, I think Lita Lambert and I and some others worked on that. Brings me to the remembrance of this guy, I think, killed this lady's husband, and he was from jail acting crazy as hell, okay, with someone that he's already violated. And something is not right. Now, in my opinion, that guy would kill somebody else again. You got those kind of people in the world. The question of it is how do you identify them? How do we make sure with my limited amount of knowledge of another human being, who should get it and who should not? To me, that's the jeopardy question right there. Now, you're going to look at a lot of the patterns, and I guess you're going to see the chance to hire that this person may do it, this, that, and other, but they do exist, and it's real. And what we have to do is try to protect them as best as we possibly can, and be fair at the same time. Now, for someone that does not get bail, do they stay for a certain period of time without having their case heard? Because we had cases where people are in jail for an extremely long period of time and they have not had bail. And how, again, do you all address someone being able to try to defend themselves if they want to, and they may be guilty? I mean, they may not be guilty.
Mr. Crump, you recognize.
Currently in Tennessee, let's say I'm arraigned today on a criminal offense. I can file a notice for a speedy trial once I've been indicted, and once it's in criminal court, I can move that case along, and I have to be tried within 6 months or that case is over. And so that remedy is rarely taken by defense counsel in my experience, and that's because they have to have time to prepare their case. If it's a case that has any significance or any sort of complexity to it, they're going to want to make sure that every I is dotted and every T is crossed. And so we don't see that filed just a lot. But in the event we do, the state is on the clock, and either we try you or you are released.
President Towns, to answer your question? Excuse me, Mr. Manguel.
I just wanted to address the representative's question with respect to how risk is determined, because I do think that that's an important matter, and it's important, I think, for this body to understand that that's not an ad hoc assessment. There are objective measures that can be applied here to assess the risk that a particular defendant poses to the public. One of the most common ways in which jurisdictions around the country have worked to do this is through the use of what are called algorithmic risk assessment tools. So the basic way to understand that is it's a list of questions that have different weights added to them. Those questions would include things like how many prior arrests the given defendant has in a particular time frame, how many prior convictions they have, their age, their employment status, and all of those things will give a score that's judged alongside a rubric that will tell you what the thresholds are for low risk, medium risk, and high risk, and that can guide judges' decisions in those cases.
Representative Towns.
Thank you for that. That makes me feel better. Now finally, gentlemen, who's going to watch certain judges that may never want to give bail at all in some cases? How do we monitor that? You know, you have judges sometimes go off on a tear and do their own thing.
Mr. Crump.
I think the best monitor will be your local sheriff because they have to run the jail. And if a judge gets in his mind that everybody's going to stay, eventually they're going to run out of space and there's going to have to be a real understanding. And I can tell you, my time as district attorney, I met regularly with the sheriff in my largest county. We had roughly 525 beds that we had available in that county. Some of that was federal inmate that brought in federal dollars to help run the jail. Some of them were state inmates that were overflow from TDOC, and then the rest were local inmates. And we would routinely go through, I along with my assistants, and look at who we're holding, particularly those that were either on pretrial release or those that are on, for example, a violation of probation of some kind, and try to determine among those if we got over our census number, the sheriff was over the census number, we tried to work with the judge and the sheriff to make sure that number stayed correct, and that we did, as I said before, those that we were afraid of, they stayed there. Those that we might just be angry at, we looked to see if we couldn't release them back into the general population, because not everybody has to be in jail pre-trial. We don't want that. Many people that are arrested pre-trial can be out and be perfectly fine. And that's really not what the amendment's going to touch. It's going to touch these folks that don't need to be among us.
Thank you. Speaker Sexton, you're recognized, sir.
Thank you. I think we also need to be very clear on what the bail means. So if y'all want to answer, if a judge right now sets bail at $100,000, what can the bail bonds company do? How much do you have to put up to get out? What's that number?
Mr. Crump, if you're recognized.
Whatever they agree to take. There is no floor. So for example, if you set $1 million bond, the maximum they can charge is $100,000. The minimum they can charge is, pick a number.
Speaker
Could
Sexton,
be
you're recognized.
$1. Yeah, so thank you. So the notion that the $1 million bills are going to keep somebody in, if you have the right bail bonds company, it means absolutely nothing, basically, is what you're saying, because they can get out for $1 if they wanted to, or $10 or $100 or whatever it is. So I think that's important as we watch and go through this. And look, I've talked to a lot of bail bonds companies. Your small independent owned that's in your community, they're not against this. They will call and say, we are okay with this because we understand that there's individuals that should not be bailed out. Now, your insurance-backed bail bonds companies that's statewide, they don't like this because they're making a profit. It's not about public safety. It's about profit, unfortunately, for those companies. And we're going to look at those later, but that's another discussion. The other thing here is there was a conversation down there about the Constitution and things could change. So when the Constitution was written and it said a capital offense, what did that mean back then? Was it defined at that point when they wrote the Constitution what a capital offense was? Or was there things added to it later that said this is what capital offense? Meaning when the people voted on the Constitution, it was unclear what capital offense was. So it could have changed or did change. Is that accurate?
Mr. Crump?
Yes, Speaker Sexton, that's accurate. It was dependent upon the will of the General Assembly, just like you all just added to the capital offense list last year, child rape. And like the federal system has treason and drug kingpin. as drug trafficking as a kingpin, as a potential death penalty. So that's always been subject to being moved and changed.
Yeah, so I appreciate that. So the notion that we're unclear of what this is a reason to use why I shouldn't vote for this. The capital offense in the current Constitution is unknown until something's added. And so I would surmise that individual probably wouldn't have voted for the constitutional amendment in the first place because capital offense was wide open and it could have changed. And so that's another interesting aspect. And I have a question for Ralph. Ralph, a lot of people want to talk about cost, how much costs it to keep these people in jail and what that means. Can you talk about the other costs that people are not considering in this aspect either?
That's exactly, yeah, absolutely. The other costs that people, I think, are ignoring all too often is the cost associated with crime, right? Crime is not a cost-free problem. It imposes costs on victims in the form of economic loss, right? A victim who is robbed is losing out on that money. It imposes victims who are physically harmed and incur medical expenses. It imposes costs on the state who has to pay police, sometimes overtime when they make an arrest, that has to pay for the court system. And, there have thankfully been economists who have done some really great work actually putting some hard numbers on the costs associated with various crimes. There's a really fantastic paper that breaks down crime-specific social costs. That is the costs that are spent on police protection, on judicial and legal activities, and corrections. And that paper detailed the low-end estimates for the social costs of various crimes like murder. Murder was estimated to be just under $9 million in terms of its cost to society. The low-end estimate for rape and sexual assault was more than $240,000. The low-end estimate of the cost of a robbery was estimated at more than $42,000. So when you consider the crimes that would be abated through the incapacitation during the pretrial period of defendants who are in the middle of a robust crime career, you have to understand that society is going to save on those crimes that are avoided.
Thank you. I got one more, Mr. Chairman. So let's just say in this bill, it talks about rape. So currently the state constitution, yes or no, says that you cannot deny bail for any offense other than a capital offense. That's accurate. Okay. That's accurate. So right now, if you have an individual who committed rape, been charged 6 times, you could not deny bail for that individual, the serial rapist. Is that accurate? Mr. Crump?
That's correct. Depending upon the way it occurred, the most a judge could do is to double a previous bail.
Right. But they get bail.
They get a bail.
Correct. If I attempt to murder somebody, but I don't kill them, I could get out on bail.
That's correct.
So if this doesn't pass, the individuals who decide that this isn't something they want to vote for, what they're allowing is a serial rapist to go free on bail, because we just said the bail company can offer anything they want to. It doesn't matter what the bail said. It could be $1 to get out. You're allowing and you're taking away the ability of the judges to keep the public safe and taking the tools away from them, or not giving them the tools because they don't have the tools, not giving them the tools to look at that criminal and say, it is better to incapacitate them than to have another victim. Would that be accurate?
They do not currently have that authority. That's correct.
Thank you.
Thank you. Members, I have Representative Scarborough on the list next, sir.
Thank you, Chairman.
Thank you, Chairman. In 1989, I went to the Tennessee Law Enforcement Academy, and I was introduced to the term recidivism. And throughout my career, 35 years, 16 as a police chief, we tried to implement many, many programs that would proactively reduce crime in our communities. And again, with much frustration, again, because recidivism term did not go away. If, in fact, as our speaker mentioned earlier, our greatest burden is to keep our Tennesseans safe, I can think of no other measure that would be more proactive than to pass this resolution. I look forward to voting for it. Thank you, sir. And that next on the list, I have circle back around. Representative Hardaway, do you have a specific question for any one of our speakers?
Yes, sir. I don't want everybody to fall out that the speaker and I are on the same page on some stuff. Okay. But and this statement is just if you agree with, I have about three things, Mr. Chairman. When you put up a cash bond, if you are a repeat offender or a hardened criminal, or if you're just such a pervert, that cash bond does not guarantee to any reasonable degree that you're not going to repeat a crime. It's just saying that whoever signed off on that bond, whether it's his grandma or whether it's the bail bondsman, the company with your assets, it's just saying that they're going to try to find you in addition to law enforcement. Is that correct?
Mr. Crum, Mr. Donovan?
That's correct.
All right. And when you're looking at the safety factors, and you were, I can't think of your last name, sir. Was it Emmanuel?
Mangual, yeah.
Manguel. All right. When you're looking at and I'm looking at the fiscal note, Mr. Chairman, it was less than $10,000. In essence, if we had the information that you have available for social costs, for the jail operations and administration, for the courts operations, administrations, et cetera, the hospital, emergency rooms, the long-term care for those who are disabled from violent crime, the mental trauma that permeates the community, et cetera, even into education. We know that ACEs, a great deal of that is stimulated by violent crime. We really ought to have a positive fiscal note on this bill, shouldn't we?
I think that's right. When you consider the total cost of crime to society, even just the calculable ones, I think there's a very good chance that the benefits outweigh the associated costs with this. And, I'm really glad that you mentioned, the psychological trauma of crime, which is something that I think is very underappreciated. I mean, there are studies showing, for example, that if you take 2 high school kids in a low-income community and you control for every factor other than one living inside the radius of a shooting and one living outside the radius of a shooting, the same kid will perform statistically significantly worse on a standardized test if they lived inside the affected radius of that shooting. The trauma associated with violent crime is almost incalculable.
All right, and Mr. Chairman, I'll just wind up by saying, as I always keep in mind when I'm voting on bills, especially criminal justice bills, that there's a delicate balance between the rights of the defendant and the rights of the public. And for me, this bill strikes that balance, and I do support it going forward.
Thank you, sir. And wrapping up the list, I have Representative Powell. You recognized?
Thank you. Just so I'm clear, some of these comments seem to have and I understand where evidence, where the presumption great here language, when the proof is evident or the presumption great. Have there been cases in the state of Tennessee that you have tried, or there have people that have been tried, where those have been unsuccessful or those have been overturned for any crime involving these listed here?
Mr. Crump?
I'm not aware of one. That certainly doesn't mean that it doesn't exist somewhere, but I'm not aware of one.
So just to be clear, none of these crimes here have ever been overturned, or there's been unsuccessful in obtaining a successful prosecution? Because, and here's, I guess the point is, we still have a right to a trial in this country. And we're talking about, and these are heinous acts, terrible things that happen. But we're still talking about people that have not fully gone through the justice system and been fully successfully prosecuted. And there's still, and I know many cases in the state have gone through that, we've looked back at the evidence, people have been convicted of crimes. I mean, I had a former colleague of mine who really wanted to go back and look at some of the civil rights cases that took place where we know people were wrongfully convicted and sometimes of murder and put to death wrongfully.
But I just wanted to I guess, confirm that, I mean, we've never had a case that's on this list that has been unsuccessful or been overturned by a court system in Tennessee.
Mr. Crump.
I'm sorry, I misunderstood your question before. I thought you were referring to the issuance of bail. Certainly, there have been cases where the presumption is great and the proof is evident where that's happened. Witnesses die. The law changes in terms of admissibility of certain things. Juries don't see things the same way as a judge and or a prosecutor. No, certainly there have been cases, and I apologize for misunderstanding what your inquiry was. There certainly have been, but that's not a function of whether or not they had bail.
Representative Powell.
And I understand that. There were some comments made where we're assuming a presumption that these people were guilty and we don't have a trial. And I understand the whole process of bail. But I would just want to reiterate, it's very important that we have a process where, people have access to fair trial in some cases people have access to bail. There are reasons that's built in the judicial system, and to blanket carte blanche, label everybody that's been just charged with one of these offenses as guilty before the trial, I think is incorrect. And so that's why I just took exception to some of those comments that were made. Thank you.
Mr. Dunn, do you have a comment, sir?
I'd like to respond to that as well. I agree with Director Crump. Anybody who's ever been prosecuted for any amount of time understands that you sometimes will lose a case that you thought you should have won. That it's an adversarial system to determine the truth, and ultimately 12 citizens at a time get to make decisions about guilt or acquittal. But you must understand that at the time that a magistrate or a judge is setting bail, or in this case, if this were to pass, making a determination of whether to deny bail, we are all operating on the same set of facts generally. Law enforcement has made an arrest. There's been an affidavit of complaint that's been filed. That defendant is in custody. Hopefully, we have information about the prior criminal history of this person, including their flight risk, their family and community circumstances. We put all of that before a judge, and we make the best recommendations and decisions that we can based upon that information that we have at that moment. Many of times, that is based upon the nature and circumstances of the crime that has been committed. There are risk assessment tools that Raphael talked about that we also can use, and so we all make those determinations in a flowing system of justice that goes forward from that moment. But where there is an indication of dangerousness to the community, which, by the way, last year, the General Assembly, you made that the first and primary consideration in setting bail, or there's a flight risk. There's a whole set of factors that the court must consider, and in this resolution must reduce to writing in a written order so that we can all review it. And within 10 days of being in custody, you have a right to a preliminary hearing, at which time the state has to put on proof and show probable cause. The court could modify that bail, could increase it, release it, do away with it. And so and even after grand jury indictment, there's a whole system of checks and reviews and development of evidence where we all are operating generally under the same set of assumptions and understanding of the facts. Ultimately, that culminates in a jury trial. And yes, sometimes juries don't see it the way we do. But that does not mean that the bail setting or determination at the beginning is flawed. It's based upon the evidence and information we have at the moment.
Thank you, sir. And Speaker Sexton, you recognize, sir. Any follow-up?
Yeah, real quick. You only have a couple of options, right? You can do no bail. You can do bail. You can do a hybrid of bail, right? There's only so many options you can have on bail. So, Ralph, can you speak to, does any states have any no bail policy?
Mr. Banguel?
Yes. So my home state of New York would be probably the worst example, where most crimes are not even subject to the setting of bail, which means that they actually have a statutory right to release on their own recognizance, which is probably one of the worst ways to go about the pretrial release inquiry. And bail can only be denied in a very small subset of cases, and it can only be denied on the basis of flight risk. It can't be denied on the basis of public safety risk. In fact, in New York State, we are the only state in the union that disallows judges from considering public safety in any aspect of the pretrial release inquiry. And I would just add that, in the criminal justice system, the very presence of a defendant before a criminal court reflects multiple determinations of that defendant's presumed guilt, right? An officer cannot make an arrest unless that officer meets the probable cause standard, which means that that officer has to determine that more probably than not, that defendant is guilty. The prosecutor will make their own probable cause determination when deciding whether or not to bring charges. And then at arraignment, the judge will determine whether or not the probable cause standard has been met before a criminal case can be continued.
And what have you seen in New York with their no bail approach?
So one of the things that we saw in the first year after the bail reform went into effect, which was 2020, it was passed in 2019, but went into effect in 2020. That year, the share of total arrests and violent felony arrests constituted by people with open cases increased by 20 and 25% respectively.
And there are states that have a no bail policy on certain crimes. Is that, do you know what states those are that mandate for these crimes there's no bail option regardless of any due process or anything?
I don't know of any states where bail is completely off the table, but there are a lot of states like New Jersey, for example, which have a rebuttable presumption of detention for a whole list of offenses. Therefore, if you are before a criminal court on any one of those charges, the court presumes, and it is the defendant's burden to rebut that presumption, that that defendant cannot safely be released.
And so the model we're going with is the middle of the road option, which gives judges the discretion to make that determination. Is that right?
That's exactly right. So the judge's hands are not tied. The defendant is not facing a presumption of detention. Judges are simply being given the discretion to exercise in either direction with respect to whether or not a defendant can be safely released to the community.
Very good. Thank you for that. Next, we'll have Leader Lambert, sir. You recognized?
Move to go back into session.
Members, any objection? Seeing none. Without objection, we're going back to session. Thank you, gentlemen. Appreciate you all being here today. Now we're back in session. Chairman Howe, back in position. That brings us back to, we're back on House Joint Resolution 49. I have Chairman Russell on the list, and Leader Lambert, I'm coming to you.
Thank you, Mr. Chairman. This is more of a statement. I just want to say thank you for bringing this resolution to us. One of our fundamental duties as a lawmaker is to safeguard lives, and this is definitely a public safety issue is what you're bringing before us. And there's a definite problem with the bail system. I've spent most of my years in law enforcement, and sometimes when I bring an inmate in the back door of the jail to book them, they'd be walking out the front door before the paperwork's done, and that would always frustrate me. And this resolution, I truly believe it's a commitment to the safety of others. And I believe in supporting this resolution for that reason. If we care about one another, we'll vote for this resolution. Thank you.
Any follow-up, Chairman Howe? Thank you. Leader Lambert, you recognize, sir.
Move previous question.
All right, thank you, sir. Members, previous question has been called. Any objection? Seeing none, looks like we're voting to send House Joint Resolution 49 to Finance, Ways and Means. Mr. Clerk, you'll open the board. Members, we're voting to send House Joint Resolution 49 to Finance, Ways and Means. All in favor, vote aye. Every member voted. Anyone want to change their vote? Mr. Clerk, take the vote.
Mr. Chair, you have 17 ayes, 2 nays, and 2 present not voting.
Okay. Thank you so much. House Joint Resolution 49 moves on to Finance, Ways and Means. Thank you, Chairman Howe. That brings us to item 2, House Bill 40. And I do not see Representative Reedy. Members, let's roll that to the hill of today's calendar. Item 2, without objection, rolled to the hill. That brings to item 3, House Bill 1169 by Representative Hemmer. I saw Representative Hemmer sitting here earlier. He looks like he's in another committee meeting as well. And we'll roll that without objection to the hill as well. Item 4, House Bill 501, Chair Lady Littleton. Ma'am, you've got a proper motion, proper second, and you are recognized. And I don't see any amendments traveling with us.
At this time. Thank you, Mr. Chairman. Right now, currently, I serve on the second look for dependent and neglect children. And they're the cases, the worst cases of children that have fell through the cracks. So we got to thinking that it would be really good if we could study the juveniles as well. So this would be a second look for juvenile delinquents to study and see, what their lifestyle was, what made a 12-year-old want to go kill his next door neighbor. So that's what this bill does. It creates a second look for juvenile delinquents.
And thank you for that explanation, Chair Lady Littleton. Do you have any questions? Looks like I do. I had Representative Johnson, ma'am, you're recognized.
Yeah, I just want to clarify. So does that include the private organizations that work through, DCS as well, that house some of the students? So it includes not only the kids in DCS, but also in the private organizations that they work and contract with?
Chair Lady, you're recognized.
Thank you, Mr. Chairman. DCS does kind of sort through the cases for us, so I'm not sure if that's private ones as well, but I'll find out.
Thank you.
Thank you. Members, any additional questions? Representative Salinas, you're recognized.
Yeah. How would the informed consent for portions of the cases that you study would take place?
Chair Lady Littleton.
I didn't understand the question. I'm sorry.
The informed consent of the samples that y'all are looking at regarding like the parents or the child themselves, are they aware that they are part of a sample that's being reviewed?
Chair Lady Littleton.
I'm not aware of that, but I do know we have to sign a confidentiality form to be able to serve on the second look.
Representative Salinas. That answer your question?
Kind of.
Any follow-up? All right, thanks so much. Members, I don't have anyone else on the list. Are we ready to vote? Any excuse me, I'll retract that. Representative Salinas, you're recognized.
I am still learning. I apologize.
Oh, you're fine.
Could we ask legal about that? The informed consent portion? I know that Representative Littleton said that they do get some information, but I would like more detail on that.
Members, any objection? Seeing none, we're going out of session. Hear from Ms. Fogarty, you're recognized.
Michelle Fogarty, Legal Services. The language in the bill states that all information that is confidential pursuant to state or federal law and acquired by the commission in the exercise of its duties remains confidential after being acquired by the commission, is not subject to discovery or introduction into evidence in any criminal or civil proceedings, and may only be disclosed as necessary to carry out the purposes of this part that's being created.
Representative Salinas, any follow-up?
So the parents and or people, when the information is collected, are aware that this is a potential thing that their information could be used for. I understand that the information is confidential, but are they aware that the information that's being collected could be further used for other things?
Ms. Fogarty.
There is no requirement that they consent. It's a study of the court records. So there's no provision in the bill to require the parent or the child to consent to allow their case to be a part of the sampling that's submitted.
But they're made aware that those records could be used to get a second look.
Ms. Fogarty.
I don't believe it provides for any notice to the child or the parents that their case is being submitted to the commission for a review. But I will double check that.
Okay, thank you.
We're good. Members, anyone else for Ms. Fogarty before we go into session? Any objection going back into session? Seeing none. All right, back on the bill. Question's been called. Any objection? Seeing none. Members, we're voting to send House Bill 501 to government operations. If you'd open the board, members, has everyone voted? Anyone like to change their vote? Madam Clerk, take the vote.
Mr. Chair, you have 15 ayes and 0 nays and 1 present not voting.
Very good. House Bill 501 moves on to government operations. Congratulations. Brings to item 5, Chairman Russell. House Bill 1020. Got a motion and a second. I don't see any amendments. You're properly recognized.
Thank you, Mr. Chairman. House Bill 1020 establishes civil immunity for a law enforcement officer who causes property damage to or inflicts personal injury upon the person during the course of the officer's duties. if at the time the damage or injury occurred, the person engaged in conduct that resulted in the person being convicted of the offense of resisting arrest. With that, Mr. Chairman, I renew my motion.
Very good. Members have any questions for Chairman Russell? I have Representative Johnson. You're recognized.
Okay, so this bill, as I understand it, increases qualified immunity. What already stands as qualified immunity, this actually adds more emphasis to that, correct?
Chairman Russell.
Thank you, Mr. Chairman. I think that was entered in subcommittee, but I'll defer to legal just to clarify.
Members, any objection going out of session here from Ms. Fogarty? Seeing none. Ms. Fogarty, you recognized. And we need a question. Let's see, Representative Johnson, you want to ask that question?
Yes, I wanted to see how this changes the qualified immunity or enhances it.
Ms. Fogarty, you recognized.
Michelle Fogarty, Office of Legal Services. This does not impact a person's ability to sue in federal court for a violation of their civil rights.
Representative Johnson, does that answer your question? Very good. All right, members, any objection going back into session? Seeing none. Next on the list, I have Representative Hardaway. You recognized. Oh, excuse me. You all look so much alike. Representative Towns, you recognized.
Chairman, you used to be one of my favorites. I'm gonna have to reassess that, you know.
Sir, you recognized.
Mr. Chairman, thank you. As it relates to the civil liability, this does not, or does it bleed over into another citizen that's not involved in this crime or another citizen's property? For instance, you know, these guys may be fleeing and the officer spins out and well, hits a house or hits a fence, this, that, and other. But that was not a part of the criminal situation. Who makes that particular person whole, that citizen whole?
Chairman Russell, you're recognized.
Thank you, Mr. Chairman. And this bill specifies that the immunity does not apply if the officer's actions were grossly negligent or willful misconduct, and it does not extend to property damage or injury inflicted upon a bystander.
Representative Towns, any follow-up?
So that bystander or that person's property is taken care of. The officer can't pay it. So I guess it would be the city. I'm thinking out loud, the city or whomever, or the municipality would have to make that particular citizen whole who was not involved in the crime.
Chairman Russell.
Thank you, Mr. Chairman. And you are correct. It's the city's not, or the counties, either one's not affected by this bill. It just covers the officer personally being sued by somebody that has been convicted of resisting arrest.
The nerve. Thank you, Mr. Chairman. Thank you.
Thanks, sir.
Thank you.
Members, that's all I have. Any additional questions? Excuse me, I have Representative Bolso on the list. I apologize.
Thank you, Mr. Chairman. To the sponsor, thank you for bringing this bill. There was an issue raised about qualified immunity, but it is true that qualified immunity does not apply if an officer's actions were grossly negligent or were intentional. Is that correct?
Thank you, Mr. Chairman. And I would defer to legal just to clarify that we get it right.
Okay, you want to just tell them now? Okay. Members, any objection going out of session here from Ms. Fogarty? Seeing none, we're out of session. Ms. Fogarty, you recognize.
Michelle Fogarty, Office of Legal Services. I'd have to do a little more research before I could definitively answer that question for you.
Fair enough. Members, anyone else for Ms. Fogarty before we go back into session? Any objection, go back into session? Seeing none. I measure back in session. Mr. Representative Bolso, any follow-up?
Just one thing to the sponsor. My understanding is that qualified immunity only applies if an officer acted in the course and scope of his discretionary authority and if his actions were objectively reasonable. So this statute, this bill before us, does not do anything to undermine existing common law regarding qualified immunity. In fact, it simply codifies much of what I believe our common law of qualified immunity is in Tennessee already. And so I appreciate your bringing this.
Thank you. Representative Hardaway, you're recognized.
Thank you, Chairman. and I really wanted to go to legal on this, but I'll trust that the sponsor might have the answer. And that's on when we're looking at what gives me concern is whether the resistance to an unlawful frisk or search, whether those are covered under this bill as being ineligible for civil reimbursement, civil liability rather, or whether there needs to be some other criminal charge attached that the defendant would be found not guilty of. Tell me how that works.
Chairman Russell.
Thank you, Mr. Chairman. It's pretty simple. If you want to have a lawsuit towards the officer personally, don't resist arrest. And that's is the definition of the statute, how it's titled. That's why it says stop, frisk, halt, arrest, or search of a person, or obstructing the service of a legal writ. That's just simply the title of the statute.
Representative Hardaway, to answer your question.
I think so, Mr. Chairman. But I think what I heard was if you think that you're at risk of bodily harm or you're just you're responding emotionally, spur of the moment, that if the officer goes too far and you do suffer physical harm or there's property that's destroyed, that even though the search may have been unjustified and may have been legal and still unjustified, that you can't hold that officer to civil liability. That's what I heard. So and if that's what I heard was correct, if the sponsor would just say yes or no, and I'm good after that.
Chairman Russell, you're recognized.
Thank you, Mr. Chairman. And I believe you're correct because we specified that the immunity does not apply to if the officer's actions were grossly negligent or willful misconduct. So I believe we're on the same page with that.
Very good. Thank you, sir. All right. That brings us to the end of the list. Members, are we ready to vote? Any additional questions? Seeing none. Any objections to the question? Seeing none. All right, members, we're voting to send, whether or not to send House Bill 1020 to calendar and rules. Has every member voted? Any member like to change their vote? Madam Clerk, if you take the vote.
Mr. Chair, you have 14 ayes, 5 nays, and 0 present not voting.
Very good. Congratulations, Chairman Russell. House Bill 1020 is moving on to calendar and rules. That brings us to item 6, House Bill 96 by Chair Lady Davis. You got a motion in a second. You're properly recognized.
Thank you, Mr. Chair. Thank you, committee. Essentially, this is just this language is just some cleanup language to TCA 8-6-112. And so I stand ready for any questions, and I appreciate favorable passage.
And thank you, Vice Chair Davis. And I know we given everyone a week to ask questions about this bill. Members, any questions for Vice Chair Davis during the past week? Representative Johnson, you're recognized.
Are you saying here that this does not expand the authority of the AG? You say it's just cleanup, but at my understanding and reading, it expands the authority of the AG. Is that incorrect?
Vice Chair Davis, you're recognized.
It does not.
Answer is no. Representative Johnson's answer your question? Fair enough. All right.
It's
Thank you. Chair Lady Littleton, question's been called. Members, any objection? Seeing none, looks like we're ready to vote to send House Bill 96 to calendar and rules. Has every member voted? Anybody want to change their vote? Madam Clerk, take the vote.
Mr. Chair, you have 17 ayes, 2 nays, and 0 present not voting.
Very good. Looks like House Bill 96 by Vice Chair Davis is moving on to calendar and rules. That brings us back to item 2, House Bill 40. Sir, you got a motion in a second. And looks like you have an amendment here coded 02041. Does that make the bill?
Yeah, yes, Mr. Chairman, 2041, it's just a date change. It does not make the bill.
Okay, it is not a substantive amendment, members. I've got a motion in a second on it. We want to go ahead and put it on. Any objection? Seeing none. All those in favor of adopting House Amendment 02041, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. You're recognized.
Thank you, Mr. Chairman. And a summary of the bill requires that the Tennessee Advisory Commission on Intergovernmental Relations to study the current availability of local juvenile detention centers and other facilities for the housing and treatment of juvenile detained prior to an adjudicatory hearing, and housing and other treatment facilities for juvenile offenders who have been adjudicated delinquent and committed to the custody of Department of Children's Services. And it requires TASER to conduct the study from existing resources and to report its finding to the General Assembly and Legislative Librarian by January 30th of 2026, Mr. Chairman.
Thank you for that thorough explanation. Representative Reedy. Members, any questions? Seeing none, we ready to vote? Any objection? Seeing none. Members, we're voting to send House Bill 40 to Finance, Ways and Means. Has every member voted? Any member like to change their vote? Madam Clerk, take the vote.
Mr. Chair, you have 19 ayes, 0 nays, and 0 present not voting.
Very good. Congratulations, sir. Looks like House Bill 40 is moving on to Finance, Ways and Means as amended. That brings us back to item 3. Representative Hemmer, sir, House Bill 1169. We're at the hill of our calendar now. Members, we have House Bill 1169, Representative Hemmer in front of us. You're properly recognized, sir.
Thank you, Mr. Chair, members of the committee. This summer I did a lot of work, meeting with a ton of stakeholders looking at children's mental health. One of the things that came across my desk that I urge you to read too, Sycamore Institute did a big study, actually a 3-phase study around all the different items in Tennessee regarding children's mental health. And one of the things they recommended was simply reinstating this Council on Children's Mental Health to submit an annual report on the status of children's mental health in Tennessee and make recommendations for system improvements, and also convening stakeholders. Surprised to learn that Tennessee's current efforts to address youth mental health are spread across 9 different agencies and dozens of programs, possibly creating some hurdles and not achieving meaningful progress. So be able to coordinate those stakeholders and resources through an annual report would provide recommendations to policymakers like us.
Very good. Representative, I understand this is something we used to do. Now we're just re-implementing. It's in the best interest of our children.
Yes.
Okay, very good. Members, any questions? Seeing none, any objection to voting on the bill? Questions will call the objection. Seeing none, looks like we're ready to vote. Send House Bill 1169 to calendar and rules. Has every member voted? Any member want to change their vote? Madam Clerk, take the vote.
Thank you, committee.
Mr. Chair, you have 17 ayes, 0 nays, and 2 present not voting.
Members, House Bill 1169 will be moving to calendar and rules. And that brings us to the end of our calendar. Members, we did have a presentation on calendar today. We've got a little over 15 minutes left. I'd like to go ahead and get these folks up here. They've been patiently waiting. I have, looks like Cody Page and Jill Schroeder. We've got a GPS monitoring presentation. So without objection, we're going to go out of session and hear from them. And folks, what we can do, if y'all want to, we've got about a little over 15 minutes left of session. And I'm just going to, after this committee meeting, I'm going to get that to you all so y'all can speak as long as you'd like to do so, whether that's 10 or 15 minutes, or you can leave some time for questions. Of course, after committee, we can share your information for members and we can go from there. But anything you all like to talk about, whoever wants to go first, just raise your hand and we'll turn your mic on, introduce yourself, and we'll go from there. You're recognized, sir.
Good afternoon, members of the House Judiciary. My name is Cody Page. I am the Chief Operating Officer of PronoTrack, located in Maryville, Tennessee. At PronoTrack, we're a full-service provider of electronic monitoring services with over 2 decades of experience. We've had the privilege of partnering with courts and agencies throughout the Southeast. We understand the critical need for reliable, effective, and responsive solutions that contribute to stronger programs and safer communities. Our mission is straightforward: to build strong, lasting relationships with the most innovative technology companies in the industry and to deliver those best-in-class solutions through a model of exceptional customer and client services. We are committed to making a positive impact on the communities we serve, and we are grateful for the opportunity to contribute to this important conversation today. I'd like to discuss the role that technology plays in offender supervision, specifically GPS monitoring devices, which have become a crucial tool in ensuring compliance with court order monitoring. Most of us are familiar with GPS monitoring in general, but I'd like to outline some of the key features that define the industry standards of these devices. First, GPS devices offer real-time tracking Most devices track the location every minute with updates every 10 minutes. One of the most important features is geofencing. This allows us to set virtual boundaries around specific locations such as the defendant's home or work. If a defendant enters or leaves the predefined area, the system triggers an immediate alert. In terms of communication, these devices are essentially cell phones worn on the offender's leg. If there's no cell coverage in a particular area, the device will generate an alert. Some devices have the ability to seamlessly switch between multiple networks, ensuring that the device is always tracking. A newer advancement in technology is the ability for these devices to connect to Wi-Fi networks where cellular service is unavailable. This ensures the device continues to transmit data, maintaining continuous monitoring, even in remote and rural areas. Another critical feature is tamper detection. GPS devices are equipped with sensors to detect if the device is being removed or damaged. If the tampering occurs, authorities are immediately notified, enabling them to take swift actions. These devices are designed to last from 24 hours to several days on a single charge. If the battery is running low, monitoring systems send alert to the supervising agency, prompting them to take action before any disruption of the monitoring can occur. Real-time alerts are highly customizable to ensure that authorities are notified of any violations, whether the defendant is leaving a restricted area, failing to charge the device, or tampering with it. One of the most important advancements in recent years has been the integration of victim notifications, which has been made possible in part by the Debbie and Marie Domestic Violence Protection Act. This law provides access to the tools necessary for the victims to be notified if an offender comes within a predefined proximity of their location. Thank you, Chairman Doggett, for sponsoring this important legislation and this committee for voting to pass it last year. When an offender enters that proximity, the system triggers an alert notifying both the victim and the monitoring authorities. This allows the victim to take appropriate safety measures while authorities are given the opportunity to intervene. In the counties we serve, this process is immediate. A text and email is sent to the supervising authority, and the call is made to the local 911 dispatch, ensuring law enforcement is deployed quickly. As we all know, an ankle bracelet alone will not prevent problematic behavior. Consistent monitoring, accountability, and enforcement of consequences are the key to a successful program. Electronic monitoring programs are heavily dependent on the correct selection of participants. Research has consistently shown that when properly applied, electronic monitoring programs can be an incredibly effective tool in the criminal justice system, benefiting both the community and the participants involved. In addition to the advancements we've seen, I believe there's a critical need for stronger, more standardized guidelines in the field of electronic monitoring. By establishing clear standards, we can ensure that offenders are monitored consistently and that the safety of the victims and the integrity of the justice system are always upheld. It is important that we not only safeguard the innovation, but also ensure that innovation is accompanied by the necessary so we can deliver the highest level of accountability and protection possible. Enhanced standards will help avoid gaps in monitoring, reduce potential for errors, and ultimately contribute to the trust and effectiveness of electronic monitoring programs across the state of Tennessee. Thank you.
Thank you, sir. Ma'am, if you would, go ahead, just introduce yourself to the committee.
Hi, my name is Jill Schroeder. I work for a company called Buddy, and we are an original equipment manufacturer of electronic monitoring equipment. Our model is that we lease our equipment to directly to agencies who want to run monitoring programs for themselves. And then we also lease out equipment to third-party vendors such as his who run those monitoring programs for entities as well. I support everything he said, and just want to add in that I believe the general cost of incarcerating somebody in a jail in Tennessee is upwards of $70 a day. And electronic monitoring can run between around $10, maybe $12 a day. And so it could signify great savings and allow offenders who otherwise would be incarcerated to attend things like treatment and to pay back restitution, keep their employment so that they can support their families. There's a lot of benefits to using electronic monitoring, and I'll just stop there.
Very good. Thank you for that. Sir, if you would, just introduce yourself.
Mr. Chairman and committee, my name is Leonard Belmaris. I want to thank you all for giving me the opportunity to be here. I'm the president of Tennessee Alcohol Monitoring Systems, or Tennessee AMS. We are a provider similar to Mr. Page. We provide electronic monitoring devices throughout the state and help implement those programs. This committee did great work last year with the Deborah Marie Domestic Violence Protection Act, and also with passing a law that allowed officers to make an immediate arrest if someone violated conditions of bail. Representative Hardaway made a good point earlier that, the bond itself is not going to protect society. But what you have here is you have a monitor to keep someone accountable. You have a judicial order that says this person can't go to this location, can't go around this victim. And by using this technology, if a defendant goes within a proximity of a victim, the victim's going to get notification. And it's like an alarm system in your home. It tells you the defendant's near your location, or the defendant has entered your home where he's not supposed to be, or the defendant has entered your work where it's not supposed to be, give you an opportunity to take evasive action. It also generates calls to law enforcement. So if a victim comes incapacitated or is in a fight, law enforcement has been notified. They have dispatched someone to the location to assist, and they're able to make an arrest if they get there. And so it's definitely been a huge paradigm shift in monitoring in the past. I come from the court system. I was practicing attorney and previously elected judge, and I serve in an interim position now. But it's definitely been a shift in that allows more tools for judges to be able to enforce their bond conditions. So, and what we're here asking for is more regulation. There's currently no body regulating electronic monitoring. It's up to each jurisdiction to try to get those regulations in place, and it varies wildly from county to county. So thank you.
Thank you, sir. All right, members, we'll open it up for questions. Representative Johnson, I have you first on the list. You're recognized.
Yeah, thank you guys for being here, because I just spoke with a constituent yesterday, which brought up something you talked about, the alcohol. So their concern was this person owns a pizza place and works with yeast. Can that affect the alcohol test? There was a concern there about working with yeast affecting the device. And like false positives, I guess, or something like that, that it could affect the device.
Mr. Belmars?
Yes, sir. It can generate an alert, but before alert can be confirmed, it has to meet a certain set of criteria. It has to start at 0. It has to return to 0. It has to meet an absorption and elimination rate that has been scientifically tested, and the device has to pass diagnostics. So it can generate an alert. It's very unlikely that alert would be confirmed. Also, it would go in front of a court for evidentiary hearing, and the judge is going to make that determination based on the credibility of the person that's testifying about those circumstances and whether they believe that is the cause of the violation. So.
Representative Johnson, any follow-up?
Yeah, well, I had one more question, because this is different kind of devices. I don't know if it's the devices that you all work with. But in the case of a malfunction, not tampered with, but the device malfunctions, it's my understanding you have a certain period of time to get that fixed. And we had a situation in the snowstorm where within the set, maybe 2 days or something, that malfunctions are supposed to be fixed. It did not get fixed because of the snowstorm in that amount of time. And then these folks get 30 days added on, even though it was no fault of their own that someone couldn't get to their device that malfunctioned and get it fixed. Is that something that you all deal with at all with your devices?
Mr. Page?
We do, devices will fail at some point. It's technology. There's possibility of failure and everything like that. But I've never seen in any of the jurisdictions that we work in where additional days are added on for anything like that. And just in the jurisdictions I work in.
Thank you. All right, Representative Doggett, you're next on the list.
Thank you, Mr. Chairman. Thank you all for being here. Not really a question. It's just more of a statement for the committee. I know that we do have multiple bills that have been filed this year that deal with GPS and GPS monitoring for various crimes and other issues. And so this is these folks that are here, they do this for a living. So I know we're not allowed to have props in our committees, but I do know that they have some of these devices and things here today, and I'm sure that they would be more than happy to show those to you after the committee and tell you a little bit more about them. But just firsthand knowledge working in law enforcement 10 years ago, I mean, technology has changed quite a bit over the past 10 years, but seeing these devices work firsthand, they do work. Victims of, especially when it comes to domestic violence, they get that opportunity of notification. And I've seen that done. And then just in the last year, since the Debbie Marie Domestic Violence Protection Act was passed last year, a constituent of mine was one of the first recipients that I knew of to obtain the GPS device for herself, and it worked with her cell phone. And she told me that it was the first time in years that she slept at night, and it was because of having that accessibility to know when her offender was in the area. So, times are changing, and this may be alternatives for things, more tools and resources for our judges and law enforcement to utilize when you have folks out on the street. So I want to encourage everyone to meet this lady and these gentlemen and talk to them more about it.
Yeah, and thank you for that. Members, we're going to have to, without objection, we're going to need to go back into session. We're getting low on time. We've got a committee meeting coming in. This staff has got to go into the next Civil Justice Subcommittee. So members, folks, I want to thank you all for being here. And I'm sorry we're a little tight on time. We had to get through some bills today. We want to just sincerely thank you for your time, for being here. Members, I would encourage you all to reach out to these folks if you have any questions about what they do. They do a good service for our state and our communities. So just thank you all so much for being here. Members, and I'll entertain a motion to adjourn. Very good.